All rise. First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. We have one case on the docket for oral argument this morning, the case of Juan Park versus United Faculty of Florida. Counsel, you may approach. Counsel, we've allocated 15 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. We initially had asked for 3 minutes. If it's okay with the court, I'd like to up that to 5 minutes for rebuttal.
So noted, Madam Clerk. You may proceed, counsel.
Thank you. And good morning to all of you. My name is John Vadel with the Fairness Center. I'm here representing Dr. Park, the appellant. This case is really quite simple. The facts are simple, the law is simple, and it really comes down to a straightforward application of the plain language of a statute. Section 447.401 of the Florida statute states, all public employees shall have the right to a fair and equitable grievance procedure administered without regard to membership or non-membership in any organization.
So, counsel, is it your contention that appellant's contention that union members have a statutory right to union representation under section 447.401?
Yes, our position is that they have a statutory right within certainly the bounds of the duty of fair representation. So our position is not that the union has no discretion in terms of deciding how to proceed, but in terms of membership status alone, the discretion that the union had has been limited by the Florida legislature. And that's really the carve-out part of the statute, where it states that unions shall not be required to process the grievances for employees who are not members of the union.
So that implies the opposite is also true then? If they're not required to process grievances for employers who are not members, then that necessarily implies that they must process, and what process is a different question, I guess, grievances for employees who are members?
It implies they must process it, and as you note, the process, what that means is
Why is the opposite necessarily true?
Well, I think the first part of the statute sets forth sort of a general rule that when it comes to membership status alone, the union cannot discriminate on that basis when it comes to grievances. There's this carve-out, there's an exception, where as to membership status itself, the union is permitted, if the person is not a member at that time, to say, no, we're not going to move forward or process your grievance because you are not a member at this moment. Where a person is a member, discriminating on the basis of membership status alone is off the table. Now, if the union wants to decide for other reasons that it's not going to move forward, whatever those reasons might be, and had they done so, we probably wouldn't be here. But the union's focus here was specifically on the membership status of Dr. Park, just not in the way that the statute authorizes. So the statute, the language of the statute is written in the present tense. So what it's saying is those who are not members, when they're seeking representation, in that circumstance, in that one single circumstance, the union can decide not to move forward and represent that person based only on the fact that they're not members.
Well, let me ask you how a different statute fits in. 447.301.2 talks about public employees shall have a right to be represented by any employment organization of their choosing and to negotiate collectively the terms of their employment. And then the very next sentence, public employees shall have a right to be represented in the determination of grievances at all terms and conditions of their employment. So the way I read that is the organization is obligated to do the negotiating on the contract, but if there's a grievance, nobody, they just have a right to be represented. They can hire somebody, maybe the union represents them, maybe not. But that seems like a pretty clear statutory distinction. One has this extra language about represented by the organization, the union. The other one doesn't. So how do you get around that?
Well, I think that we would agree that there is flexibility in whether or not a union is going to represent an individual. What this statute is specifically addressing here, the 447.401, is membership status itself. There's any number of factors that might go into whether a union wants to represent an individual, and the employee has the right to choose not, even as a member, to choose not to seek out the representation of the union. But what's at issue with this particular statute is this is specifically discrimination based on membership status. And what the statute allows is a one limited circumstance where the person is not a member in the moment that they seek representation. But what the union did was look back in time and look at Dr. Park's prior membership status and make a decision only on that basis. And that's what's outside the scope of this statute.
Well, and I would agree with you that we've got to follow the text of the statute regardless of public policy to the contrary. But wouldn't you agree that your reading of the statute provides a free rider problem, that somebody can avoid joining a union, then they get some notice that they've got a problem with their employer, and they go run to the union, join and pay the dues at that point, when for years they hadn't been paying their dues before, right?
Well, I'm not prepared to call anybody a free rider today, but I would agree that there may be a more equitable way of wording the statute. There might be another exception that might create more fairness for a union. But these are policy decisions ultimately that is in the hands of the Florida legislature. And when it comes to membership status, discrimination based on membership status by itself, not factoring in any other, issue or characteristic, not factoring in whether a union just simply doesn't want to process it.
Well, if they've got discretion to decide, okay, we don't, yeah, you're guilty of whatever the employer said, some horrible crime, we don't want to touch that. The union doesn't want to touch that. Or you're asking for us to do something that is harmful to the union itself. We don't want to touch that, right? So you would agree that the union may have the ability or the discretion to avoid those kind of issues. So why doesn't it have the discretion to say we have limited resources, we have a 1 week member or a 20-year member, we're going to devote our resources to the 20-year member, we're not going to devote our resources to the 1 week member?
Well, they do have their discretion to make a decision based on resources. What they don't have the discretion to do outside, with the exception of what this statute allows, is to state that because you're not a member, not because we don't have financial resources or not because we don't like the merits or whatever, but because you were not a member at an earlier time, we're not going to represent you today. What the statute only allows, as the statute is we read this as being relatively narrow in scope, that this is strictly about a particular classification, member or not member. And what the statute says as a general rule, that when it comes to the grievance procedure and how it's administered, whether you're a member or not a member, if you are one of the public employees represented by the union, you can't be discriminated against based on that member status, except that if you are not a member, in the moment that you're asking for representation, the union can say, no, we're not going to do that. But if you are a member, and Dr. Park was a member when he asked for representation, this statute does not allow, the carve-out to this statute doesn't apply, and that general rule does apply. And that general rule says that you cannot discriminate based only on that membership status. Like I said, there could be any number of reasons why they would choose, such as financial resources, not to move forward. That's not what happened here. And I think the record really makes that pretty clear. If I could draw your attention to just a couple of parts in the record, just for your awareness. In page 240 of the record, this is in an email from April of 2023, April 10th, 2023. And this is, for context, this is right after Dr. Park joined the union and then asked for the union to represent him. And this email is from Nancy Rogers, who is the union's grievance committee chair, and she's writing to Dr. Park. And she says, I'm glad to see that you joined UFF. So she's acknowledging that he is, in that moment, a member of the union. But she says, however, as I said before, I can only represent people who were members at the time that an incident occurred. And if you look forward to page 273 of the record.
Before you finish with that, I was interested in the phrase, as I said before. Is that indicated in the record, what she's talking about?
That's part of it's what I read as part of an email chain. So when Dr. Park first joined and then asked to be represented, the union initially thought he was not a member and said no. When he clarified, no, I actually am a member, she said, oh, we can't represent you with respect to, it was confusion as to, she said she couldn't represent him with respect to the fact that the incident predated his membership. There was confusion as to what matters as to predating membership, because the investigation that he was seeking representation for hadn't yet occurred. And so that, when she said, as I said before, they were kind of going back and forth to clarify, I'm not talking about the investigatory meeting, I'm talking about the events that give rise to that meeting, if that makes sense.
And Judge Winokur had raised a point before that 447-401, the exception, the carve-out there, except that certified employment organizations shall not be required to process grievances. Process is a different word than represent. I didn't see either of them defined statutorily, but what requires, beyond just processing, the representation? How do you get representation from the word processing, I guess?
Well, so process is, I agree, we don't see a definition either, and it's sort of the nature of the duty of fair representation that there's no prescribed course of action that has to happen. It's more of a negative duty, what you can't do versus what you have to do. And so when we read process, we see that as meaning the union is taking some step beyond simply saying no because you were not a member before. And so some step that, whether we say process or represent, or what we're ultimately meaning is something more than what the union did. And so what the union could not do is what they did here. And they could not go back in time and base this on a previous non-member status. If they wanted to make a decision based only on membership status, it had to be if Dr. Park was not a member at the time that he spoke to them and asked for help, and he was a member at that time.
Is it your position that the union cannot deny representation to a union member in any grievance process, or is it your position that the union cannot deny representation to a union member in some circumstances, such as this?
It's our position that they cannot deny a member representation based on prior non-member status. So based on the fact that he was not a member for long enough, our position is not that they can never deny representation of a member. They certainly can. They have that discretion. But that's not what they did here, and that's what the record shows. They based this on the fact that at some earlier point in time, he was not a member, and that is outside the scope of what the statute allows.
Have you raised a constitutional challenge in this appeal?
We have. We've preserved it. I will say that we believe this is a case that can be decided on statutory grounds and avoid wading into the constitutional issues, and we think that's how it should be decided. But just to briefly address it, we do believe that there is a general, we understand the U.S. Supreme Court has.
Before you go into that,
Sure.
what do you mean when you say we've preserved it? I mean, PERC doesn't have the authority to address constitutional challenges, so how can you preserve? What do you mean by we
Preserved it
preserved
for this court, Your Honor. So we noted.
Preserve means that you give the lower tribunal an opportunity to rule on something, and because they don't have the authority to rule on it, how did you preserve it?
Okay, sure, that's absolutely a fair point. I guess what I meant to say was we wanted to signal that we believe that there could be a constitutional issue depending on how PERC would rule. And really it gets back to this McDonald decision that the PERC ultimately relied on, where the union in that case had a policy of not representing people based on, if the underlying conduct predated membership. But in that case, which it does not apply because the facts don't fit. In that case.
Is PERC required is there stare decisis effect to their own decisions for later decisions?
That's a good question. I don't actually know offhand. That's certainly how they are acting. That's certainly how they've decided. We think in this particular case, McDonald is not consistent with the statute. So even if PERC is going to apply a stare decisis on itself, we don't think that has any deference for later courts. Because the issue in McDonald was they understood that it was present day membership status that mattered. And so they had a workaround where they would essentially kick somebody out of the union retroactively and return all their dues to them. and then say, well, you were never a member in the first place, so therefore you could not have been a member when you asked for help, therefore the carve-out applies.
Is Dr. Park still a member of
He's
the
still a
UFL?
member, Your Honor. That never happened. So there was no workaround. So McDonald really doesn't authorize what the union did, and it doesn't apply here on the facts.
Assume for the sake of argument that we find that Perk's ruling does not conflict with the plain language of the statute. Do we reach your argument regarding the McDonald decision?
I'm sorry, I didn't quite catch the first
Assume
part.
for the sake of argument, we find that Perk's ruling does not conflict with the plain meaning or language of the statute. Do we reach your argument concerning the McDonald decision?
I don't think you need to, Your Honor. Frankly, I don't think McDonald really applies here at all. The value of McDonald's in this case is just to show that at some point the union and PERC understood that it was present-day membership status that mattered and not prior-day membership status.
Does section 1001.7412 apply to you or to the appellant in this case?
We don't really think it does. There is a separate case, a separate employment case about that particular statute, which seems to deny the right to arbitration. This case is really just kind of about this statute here, the 447.401, and whether or not what the union did here was consistent with that, which we believe it was not.
Thank you, counsel.
Thank you.
Your time has expired. However, we will extend your rebuttal time for 3 minutes.
Thank you.
We'll also extend counsel for the appellee's time by an additional 3 minutes.
If it please the court, I'm Toby Lev, law firm of Vegan, Lev, and Suega in Orlando, and we're representing the Appellee United Faculty of Florida. First, I'd like to address this issue about how to interpret the statute. Dr. Park claims the union is compelled to represent him. He misrepresents or misreads the statute, which consists of 2 independent clauses connected by the words "except that," which means in context, however. Each independent clause has a subject and a predicate. Each addresses separate topics. The first clause addresses the right of the employees, and the second clause addresses the obligations of the union. Dr. Park, before PERC and in his initial brief, took a very simple reading of this statute and said that there are 2 classes of employees, non-union member and the union member. All union members must be represented by the union in the grievance process. That's what he said to PERC, and that's what he said in his initial brief. Now he's kind of finessing it just to get an exception for his particular type of employee. But on the face of it, in his analysis, he's claiming that the statute compels representation of all employees, which is contrary to the Supreme Court's Galbraith decision.
Counsel, that's not the way I understood the argument. I mean, it could have been that there's a little nuance put on it. Not
Right.
that they're required to represent all employees who are members. Maybe they have to, maybe they don't. But what the union is doing is calling Dr. Park a non-member. So the issue isn't whether he's a member and they're going to represent him or not. They're considering him a non-member, at least for this particular instance.
he
He's a
is a
non-member
member.
because it arose when he was a non-member.
They told him that any future dispute that arises after his membership, they can represent him.
Sure.
But for this particular instance, they're going to treat him as if he was a non-member because...
So it's a question between member and non-member, not a question of their discretion to represent a member in a particular instance.
Well, I think his argument to PERC was broader, and he's saying that all members, regardless of anything, get representation, which I think is contrary to what the Galbraith decision said. And I think what you're terming a nuance is a kind of a shift in position to narrow this exception he's talking about to protect him while allowing the union to make a decision as to merits on everybody else. So I do think it conflicts with how Galbraith interprets the statute, which is the union has discretion with regard to members and non-members as to how far they want to take representation. There's another conflict with Galbraith, and that's whether or not a non-union member who processes his own grievance can get a fair and equitable grievance process, or whether without union representation he can't. That's in his constitutional argument. And Galbraith says that the fact that the employee can represent himself shows he's protected under the statute. It doesn't buy into this fact that no absent union representation, impossible to have a fair and equitable grievance process. Dr. Park has utilized the grievance process. He took it as far as any union member could take it for the first and second steps of the grievance procedure. Let me talk about the validity of the union's rule. Dr. Park wants to impose this very high burden on the union. It needs a substantial amount of data to show there's going to be some severe consequences to the union. They might suffer some imminent collapse unless they maintain this rule. The jurisprudence has been the courts do not scrutinize unions that severely. The high burden he wants to apply is at odds with the law. The courts in Perk have avoided interfering with internal union affairs. According to their policy, a rule is only unfair if it violates this duty of fair representation, meaning it's either arbitrary, discriminatory, or in bad faith. Absent a breach of the duty of fair representation, the union has a broad latitude to enact rules. There's an interesting discussion in this airline pilot's decision from the Supreme Court we mentioned in our brief, and that case likened the relationship between the courts and the legislature to the relationship between the courts and unions. A court will look at what a legislature enacted to see whether it furthered a legitimate goal, but it will give the legislature wide berth as far as the means it chose to further the goal. It will not second-guess the legislature.
So, Counsel, you said that, I think there were three, and I can only remember two off the top of my head, that as long as the union is not acting in a discriminatory manner, in bad faith.
Or arbitrary.
Arbitrarily, thank you.
That's the
Then
litany.
they haven't actually violated the law.
They haven't
with
violated this
disrespect.
breach of representation.
So how would you describe your union's policy and reasoning for refusing to represent Dr. Park that is none of those things?
Well, very easily. The union, like any organization, has operating expenses. It cannot long survive if its members know they can join after a dispute arises and then drop out after they receive union representation. It's a very dangerous precedent. The union needs to keep its assets and expenditures in balance, and it can't afford to have a lot of people refusing to join because they can always get union representation anyway the day after a dispute arises.
So, Counsel, did the membership registration form appellant completed inform him that the appellee would not provide representation for a grievance based on events that predate his joining of the union?
Well, here's where the PERC dismissed the case without a hearing. There are facts not in this particular record where the union website told the employee we would not represent people in disputes that arise before they become members. And they also told them throughout this present controversy, and Dr. Park had the option of saying, well, in that case, I'm revoking my membership, send me my dues back, which he never did. So he would have been on notice had he looked at what the union's policies were before he joined, and after he learned about it, he could have dropped out of the union and gotten his dues back, and he's still a member of the union, which makes me wonder why he's doing what he's doing now instead of representing himself and avoiding all this expense.
I have one curiosity based on the reason you gave for the lack of representation. Suppose, I'm not saying this occurred here, suppose someone is convinced to join the union, thinks it's a great idea. And 2 years later, they are investigated for a matter that occurred 3 years prior. In other words, before they joined the union. So in other words, they didn't join the union in order to get the benefits of representation necessarily for an existing event. They didn't know about the event, but the event did in fact occur prior to union membership. In that case with the union, I feel like the reasons you gave for the union's refusal to represent somebody doesn't occur in that situation. Would the union represent someone in that situation?
Well, it's a hypothetical case. I would
It is.
think they would, because the employee would not have been aware of the dispute until years after he joined the union.
So it's not strictly based on whether the incident giving rise to the discipline occurred before union membership.
Well, I'd say that whether the employee's awareness of the incident arose before he became a member would probably be a more precise, accurate way of stating it.
Counsel, do you agree with the appellant's suggestion that the term "to process," as used in section 447.401, means to provide representation?
No, I don't. If there was no possibility of the employee representing himself, and if necessary and desirable, hiring another lawyer, then there could be a deprivation of due process. But under the statute, the employee can represent himself or hire somebody to do it, so there's no violation of due process. The Galbraith court never thought it was a violation of due process, so long as the union has a right of self-representation. And I might point out this Janus decision from the United States Supreme Court said that the union does not have to represent the non-employee in a disciplinary procedure, or if it does, it can make the employee pay for the service. That the constitutional infraction there in that case was trying to make the employee pay union dues, thereby compelling him to subsidize union speech. But the Supreme Court said to the union, you don't even have to represent somebody in a disciplinary proceeding if he's not a union member, or you can charge him for a fee for the service. I also filed a notice of supplemental authority involving a Second Circuit decision involving New York's Taylor law that said about the same thing. I think the appellate's firm is representing Dr. Park today, and they cited this language from the Janus decision and said union is not compelled to provide the representation. If it does not violate due process. Galbraith has said, Perk has said, the employee can represent himself. I'm accustomed to employees going to small claims court themselves, representing themselves, or Dr. Park did and could hire an attorney, which he did. No Florida court has ever considered that a denial of due process, and when the statute was enacted, the legislature never thought the employee was being denied due process or access to a fair and equitable grievance process if he had to process his own grievance. So talking about this statute, it's now about 50 years old. It's never been revised. PERC has enacted several cases. No court has challenged or overruled Galbraith. The legislature recently revised the statute in many particulars, but not this one, that let the language here remain. There's no facts in the record to show what kind of insurmountable obstacles Dr. Park's lawyers faced because they weren't union representatives. How much time do they have to reasonably spend on the case? What documents could they not get? How are they disadvantaged in a way that a union representative would not be disadvantaged? None of that's spelled out in the record, and there's some assertions in the brief that I think are just conjecture and probably at conflict with reality. In any event, there ought to be something in the record before the court makes a decision about whether 447.401 is unconstitutional or impractical or impossible for a non-union employee to process his own grievance. Did I start down from 15 minutes? I'm only trying to do 7.5 minutes and let my co-counsel do 7.5 minutes.
You're down to 4 minutes and 39 seconds.
Oh, for the both of us?
Total, that is correct.
I need to sit down. I should have sat down 2 minutes ago. Thank you.
Thank you,
Ron.
counsel. We defer to counsel how to allocate their time for the oral argument.
Thank you, Your Honor. I'll be brief, as I must. Glenn Bassett, Special Counsel with the Florida Office of the Attorney General, here for the Public Employee Relations Commission. We're in mostly agreement that this case depends upon the interpretation of Section 447.401. But there's a different view here that I would ask the court to take. First of all, the background for an unfair labor practice, the employee must cite to a right that's within Chapter 447 that has been violated, in this case violated by the union, because that's the nature of this particular ULP. So it has to allege that the union interfered, restrained, or coerced the employee with respect to that right that's identified. Here, the right that he attempts to identify is in Chapter 447 in Section 401 there, which we've been talking about. But the language there is crucial, as I think everyone here would say the same, but it's that all public employees have the right to a fair and equitable grievance procedure is the first part of that. Well, the grievance procedure, that's the mechanics of what goes on for a grievance. That's the form that's used, that's the timing, that's who it goes to, what the different levels of grievance processing are at the employer. That's what that is talking about. That's the right that the employees have, the right to have a fair procedure in place for processing grievances. The second part is not really a proviso the way that I view it, because it's shifting gears to what the union may exclude from its representation there, from its processing there. And so it says the union may exclude those who are non-members. That says nothing about a right for members, a right for anyone. It is an ability for the union to exclude non-members from that process.
What does the phrase "accept that" mean in the sentence? What exactly is being accepted?
Your Honor, I don't know what they meant by that. It wouldn't be the first time that I've been confused with statute. But if we put those together otherwise, if we say, well, that's all part of the union, it would say that you process regardless of membership or non-membership in the union, except it does matter if non-membership in the union. So those don't really fit together. It's like an add-on that they decided to graft in there. It doesn't say it's a proviso, which often statutes do, and this does not. But clearly, that does not create a right for anyone. It doesn't say that any person has a right for the union to process a grievance. And that right has to be specific. For an unfair labor practice, the employee must identify the right. It's not an implied right. It's not what you think the right is. It has to be something you can point to in Chapter 447 that's a right for you that the union has interfered with. So the union didn't interfere with the overall process with regard to Dr. Park. They simply didn't represent him, which goes to that, accept that language. But they had, that language doesn't say anything about others. Within that, the union would have a right to exclude any union member for a variety of reasons. And the courts have recognized the Galbraith decision that merit is an issue. And Galbraith actually equates merit with taking a position that the union doesn't agree with. So it's not just meritorious on whether we think you'll win or lose. It's the union may decline based on merit, saying that you are addressing something that is contrary to what the union wishes. And I'm sorry, Your Honors, I've exceeded my time, but I thank you very much. Do you have any questions in addition, though, Your Honors?
No, you,
Thank you very much, sir.
thank you, counsel.
So just one point I'd like to make to start out here is what we did not hear in the argument and what we did not see in the briefing. And that is that our understanding of the statute, of that carve-out, is wrong, and that it allows them to look in the past at prior member status or non-member status. They have not articulated any other reading of that other than the fact that that clearly allows discrimination on non-member status only if that person is not a member in the present moment. And I think that as a matter of canons of statutory construction, we don't disregard language of a statute because it makes our chosen interpretation more difficult to reach.
Counsel, I believe Mr. Bassett was arguing that had the legislature intended to say that certified employee organizations shall be required to process grievances for employees who are members of the organization, it could have done so, and only then would appellants focus on the tense used to be appropriate.
Well, I think what the statute does is it does create that type of understanding. It creates a general rule where membership status alone cannot be a basis to discriminate on the type of grievance procedure that's provided or how it's administered, and that there's only an exception when the individual is not a member in the moment, and that exception allows the union to say no. But when that doesn't apply, we go back to the general rule that membership status by itself is not a basis to discriminate in how the grievance procedure is set up or administered. And so I think that's within the idea that a member of the union, as Dr. Park is entitled to something more than simply no thank you because you used to not be a member. That's understood within that general rule that membership status by itself can't be the basis of discrimination unless it falls within that exception that the legislature has provided. And in this case, that exception does not apply because Dr. Park was a member at the time. And that exception only applies to non-members at the time. And I think that, the response from the appellees is assuming a lot of facts not in the record. There's a lot of discussion about this could have been a merits decision, this could have been this, it could have been that. But I think what the record clearly shows is this was purely 100% a decision that was based on the fact that at an earlier time, Dr. Park was not a member. Anything else that they're trying to rationalize this with to get it within the scope of the duty of fair representation is speculation, and it's basing it on facts that are not in the record. I see it looks like I'm actually out of time, so I will, unless there's any further questions, I won't take up any more of your time.
And thank you, counsel, for
Thank
your
you.
respectful oral arguments this morning. This concludes our oral arguments for this morning, and we stand in recess.
All rise.